Today on the podcast, estate planning documents that you need to fill out with your loved one. The Nursing Home Abuse Podcast is dedicated to providing news and information for families whose loved ones have been injured in a nursing home. Here are your hosts, Georgia attorneys Rob Schenk and Will Smith. Hey out there, welcome back to the podcast. My name is Rob. I'm going to be your host for this episode. Today we are talking about three types of documents that are going to be important for you and your loved one to execute. If your loved one is going into a nursing home, then these three documents are going to be crucial if something happens. Those being the advanced directive for healthcare, the power of attorney, and then what's called a post. And we are going to get into detail about what each one of these documents does and what effect they have on how your loved one gets treatment. But before we get into it, please, my only ask is that you like and subscribe to this podcast wherever you get your podcasts from. Be sure to go to our YouTube channel. Check us out there. All of the podcasts are in video form. You can see our beautiful faces there. Just like today, you'll be able to see me talking to our guest in video form. Leave a comment while you're there. Hit the notification bell. And with that, let's get into the content. So again, talking about these documents, they're going to be extremely important if things happen to your loved one. We're not doing that alone. We have a guest. Actually, he's a veteran to this show. He's been on multiple times. His name is Scott Fields. He is a probate and real estate attorney in Tucker, Georgia. He is married, has four grownish sons. Scott grew up in the Atlanta area and has lived in Tucker for over 20 years. Scott graduated from Georgia State University College of Law in 2011. For over 5 years, for 5 years, now 6-7 years, Scott was a real estate, small business, and probate litigator. Since forming his own firm in 2017, Scott is focused on helping families probate estates and deal with inherited property, and we are so glad that he is bringing his expertise back to the program. Scott, welcome to the show.
Hey, thanks very much. Happy to be here.
All right. Scott is a veteran of the Nursing Home Abuse Podcast. We've had him on at least a few times in the past talking about last wills and testaments. And also, I believe, didn't we have you on for guardianships now that I'm thinking about it? Maybe.
No, I didn't do guardianships. I was on for probate.
Probate, that's right.
For probating a will after someone passes, yeah.
That's right. It's like Scott and Richard Mollett are competing for the most amount of guest appearances on this podcast for anybody that's keeping up with that minutia. Anyway, today we're having Scott on, as I mentioned at the top of the show, about critical estate planning documents other than the last will. So if you want to know more about that last will, go to the episodes, previous episodes, and we'll link those at the bottom. So today, Scott, it looks like you and I are going to be going back and forth on three types of estate planning documents. The first is the advanced directive for healthcare. The second is just a typical durable power of attorney. And then this is something new to me. And again, this is why I defer to you, but the POST, which is an acronym. So we'll let you explain that in a minute, but let's start. What we'll do is the advanced directive for healthcare. What is it? Why is it important? When should it be executed?
Sure. So an advanced directive for healthcare is basically a document that it actually does quite a few things. You should probably get one as soon as possible, especially during COVID. We'll take care of that question real easily. Get one tomorrow. Advanced directive for healthcare is a combination of a number of forms that we used to call healthcare power of attorney, a living will, HIPAA release, and guardianship nomination. So two decades ago, the state of Georgia kind of combined all those forms into one, called an advanced directive for healthcare. It is a statutory form, which means the text of the form is actually in the law books of Georgia. So you can go and, if you have a Lexis or a Westlaw subscription, you can go ahead and download that and format it however you want. People can download those at a lot of different places. The problem with downloading and trying to fill it out on your own is that the document is actually pretty complicated. Not so much complicated as poorly written. My apologies to any Georgia legislators who are listening to this podcast, but it's a mess. There are places where the person initials to give power. There's places where the person initials to take away power. So we normally recommend, finding whether it's an attorney or a healthcare professional to get some advice. But basically, we'll go through kind of the four parts of the advanced directive. The first one, and really the most important one, is the healthcare power of attorney part. And it is where you nominate a person to make healthcare decisions for you, either because you're unable to, right? Whether someone has dementia or is incapacitated, or because you simply don't want to, right? And, you've had clients, I've had clients where you get to a particular point in your life and you're in the hospital and you're like, you know what? I'm done talking to doctors. Here's my daughter, talk to her. And so, you nominate a person to be your healthcare agent, and that gives them the ability to make healthcare decisions on your behalf, right? To choose, yes, let's do this, let's not do this. And if that's the only thing that people signed, and it is possible to just make that choice and do that part of the document, that's great. We actually have a number of people come in when they turn 18 before they go away to college, and that's all they do. They come in, they nominate usually their parents, but they will come in, they'll put some names for a healthcare agent. They don't want to deal with the rest of the document. They sign it and walk away. It's great. And in that case, it does its job.
Okay. So a couple of things with this, Scott.
Mm-hmm.
One is a comment. The other is a question.
Sure.
My comment is, isn't it funny that the point in my understanding, the point of making it a statutory document, meaning that it is a template that sits in the code book and theoretically is accessible to every Georgian for use.
Yeah.
It's not easy to use because it's kind of complicated. So I think that's interesting. We've made it available for everybody. Here is something that we will by default say is useful and usable and enforceable, and here it is a copy of it for everybody, but it's kind of difficult. You would still need to get an attorney to kind of look over things for you.
Yeah.
I think that's kind of interesting, but I will do the best I can to find a downloadable or a link to that statutory template and put it in the show notes.
So I did just real quick, I did a blog post on my website earlier this year, I think, that actually does have a link. And it also has instructions on how to fill out the document, just on the basics of filling out the document. Because again, it's pretty complicated. It's drafted by legislators who are lawyers, maybe with the input of doctors, medical professionals, neither of whom, I think we can all agree, are the best at explaining things in layman's terms. And so basically you kind of need an amphibian, somebody who can kind of look at the document, understand what it means, and then explain it to someone whose primary job is not legal and medical jargon.
And what Scott is trying to say, that he is the frog for you. Okay, so my question then, Scott, is it a misconception? Is it true that simply for the fact that you're married does not mean that you can make those decisions on behalf of your spouse who might be incapacitated?
If there is no advance directive, then Georgia law does give priority has a priority list of who can make these decisions, and your spouse is pretty high on that list. So if you want to run the risk of having that happen, and the amount of hoops that your spouse will have to jump to be able to get that, I don't know. But it makes things easier to have an advance directive. And if the person who's on that priority list isn't perhaps someone that you want to either make those decisions or that you want to burden with having to make those decisions, then you do an advance directive in order to do that. Because again, once you get to a medical facility, once you get to a hospital or someplace, and there is no advance directive, on the practical side, what you're going to have is the medical professionals will pause. They'll kind of say, wait, hang on a second. We're going to need to get this done. And now all of a sudden you're having to get a lot more people involved. Whereas if you've got an advance directive, you can just kind of hold it up and hand it to them. Or even better, if they've already got one on file, when we do advance directives, we tell people send a copy of it to your healthcare professionals, your primary care physician. If you're living in a facility, go ahead and give a copy of it to the facility management. Send a copy to your health insurance company. Just kind of hand them out like candy. And so that way you don't have to deal with it when the time comes. But short answer, yeah, it's possible for, without an advance directive, for your spouse to make those decisions. It's just harder.
It becomes problematic if there's infighting with regard to what
Oh
happens
heavens, yeah.
to the resident or the patient.
Yes.
So I cut you off, man. We're powering along with the advanced directive for healthcare.
Sure. No, that's fine.
What else does it do?
So the other thing it does is what we used to call a living will, which allows you to state some treatment preferences, end of life treatment preferences. I want breathing assistance. I don't want breathing assistance. I want food by tube if I can't, take nutrition by mouth. Do not resuscitate. That's kind of the big one everybody always asks about, a DNR. But basically, if my heart stops, my breathing stops, do you want, or does the person want, CPR to come in and try to start that back up? A lot of people don't. Some people do. So the advanced directive allows people to kind of get that in writing and get that out there. Another thing that it does is a guardian nomination. So basically, the advanced directive doesn't necessarily have to go in front of a court. It's not something that you have to take and give to the court and have them approve. It's a document that basically kind of you give to your healthcare providers and to your healthcare agent, and it usually just gets used in that situation. It is possible for an outside person to come in and go to the court and say, hey, wait a second, either because there's not an advanced directive and we need to get someone appointed to make a lot of decisions, or because the outside person thinks that the agent, the nominated agent, isn't doing a good job, that person can go to the probate court and ask for guardianship. They can ask that a guardian be appointed. And Georgia law allows people to do that. And the good news is that if the person, right, who's, I guess, incapacitated is the best way to put it, if that person has in the past nominated someone to be the guardian in writing, then Georgia looks at that nomination, that choice made by the person, is at the top of the priority list. And then after that, you go down, like spouse, family, da 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 da. So and I've had a case where we had an outside person come in and petition the court for guardianship for someone who was incapacitated. And fortunately, that person had already nominated a guardian. And we kind of, when we went to court, we showed the documents, like, here's the nomination of guardian. And the judge looked at the outside party and said, what do you have to say? And they made kind of a weak argument about how they'd do a better job. And it was a bad argument. And, the judge said, all right, well, the person that was nominated is the guardian. And we moved on. So that's very helpful. That's great, because a guardianship fight is ugly and expensive, and I don't do those anymore.
I can imagine. And I would say that for me, that's one of the critical reasons why an advanced health directive or advanced directive of health is important, is that nomination of a guardian. Mm-hmm. And it comes into play in my experience because you might, as your loved one might go into that nursing home with full cognitive capacity, but oftentimes that's lost. And at the time that it's lost, they can no longer execute documents.
Yeah.
They don't have they might not have the capacity to do so. And then at that point, you're doing what Scott said, which is having to petition the court for guardianship over your loved one. And depending on how your family dynamics are, there might be a fight for who gets to be guardian. So doing this before anything happens to your loved one is critical, because that can really save you a lot of time, save you a lot of money, and save you a lot of fights with, your cousin that you haven't seen in 15 years.
Yeah. Yeah. And once you cross that particular Rubicon where the person can't sign documents anymore, everything gets much, much more complicated, gets much more expensive, and the timelines begin to spread out. And what do you do when there's an emergency surgery that has to be decided? You don't want to spend a couple of weeks waiting for a court hearing or waiting for a judge to rule on something. So yeah, this is a big one. The other big one that we get, especially again with younger people, right, is they turn 18, go away to college, or just even, enter the workforce. But once you turn 18, parents can't access medical records anymore. And so the advanced directive includes not necessarily a release, but it is a statement that the healthcare agent does have the authority to access medical records. So again, we do these for kids going away to school or when they turn 18. They usually nominate their parents. Sometimes they don't. And then I get to tell the parents that I can't tell them who the kid nominated. And yeah, that's a fun conversation that they then get to go have with their children.
Uh,
But yeah, so and that's very important as well. And then the last thing that the advanced directive does is it gives the healthcare agent some instructions on what happens after someone passes away. So that involves things such as organ donation, the donation of body for medical research, whether someone wants to be buried or cremated. So by default, the healthcare agent can make all those decisions themselves. If someone has a preference, they can essentially remove that authority on the document and say, no, I don't want my healthcare agent to choose whether I'm buried or cremated. I want to be buried, or I want to be cremated. There's also an interesting part that allows people, it's kind of an other, right? It's the notes kind of piece where people kind of put in anything extra. We see it's useful in places or in situations where there's religious observances. We see like last rites, or in certain religions, you can't do a blood transfusion or things like that. Those instructions go in there. We have also seen things like funeral instructions. That actually happens a lot. I wish my ashes to be put in this place, or that sort of thing, because it, you might as well, it's there. I've also seen someone put in what kind of beer they want served at their funeral, what kind of rock music they wanted played at their funeral, that sort of thing. And we put it in there. Whether that is enforceable, I don't know. I've never had that fight.
Exactly. At least it just, no one's going to file an injunction to get, the greatest hits of Journey played at a funeral, right? Or like, well, we're not going to blast your ashes into space in a rocket ship. So
you'd be surprised at what people go to court over. I wouldn't be surprised if someone did try to enforce something like that, but I don't want to be that attorney.
Right. Okay. So it looks like we've beaten up advanced directives for health. Pretty good. So let's talk about power of attorney again. What are those? What do they do? When should they be executed?
Sure. So whereas an advanced directive deals with instructions about healthcare, power of attorney deals with essentially your stuff. It's your property. It's real estate. It's what we call personal property, which is movable, tangible items. And then money and financial assets. Again, stuff is the normal term. And basically what it does is it appoints a person to make decisions on your behalf regarding your stuff. The agent is what it's called. The agent always has to make these decisions for your benefit. Once you name somebody as your financial agent, they can't all of a sudden take your bank account, empty it out, and go to Disney World. They can, it's physically possible, but then you can sue them.
Right.
Because it's not legally permissible. So they always have to use your assets on your behalf. But essentially, you're just kind of authorizing someone else to kind of help out. We see it a lot with our older clients where they're sick of going to the bank or they're sick of writing checks. And so they rather than put their child on a checking account, making it a joint account and causing all sorts of problems in probate, instead we just get a power of attorney and put the kid on the account as a power of attorney. And then they can write checks, they can move money around, they can do these sorts of things. They can sell houses. I had a question earlier today about a power of attorney and trying to get a house sold. And again, they can deal with tangible personal property like selling clothes, selling jewelry, moving items from a safe deposit box or putting them into a safe deposit box on behalf of the principal is what the person's called who's making the power of attorney. So, and you mentioned earlier about durable power of attorney. There's really kind of two general classes of a power of attorney. One is called durable. A durable power of attorney is one that starts essentially immediately. As soon as someone signs it, the agent has the authority that's given in the document. And then the reason it's called durable is that it lasts through the principal's incapacitance, which means the person who makes the power of attorney, if they then become incapacitated, dementia kicks in or they're in a coma, that power of attorney will continue through. Incapacitance used to, a long time ago, kind of wipe out a power of attorney. So we started making them durable so that they continued through, because that's kind of the point, right? The other kind is called a springing power of attorney, which does not take effect right away. There is a trigger. There is some event that will cause the power of attorney to become active. Usually it is when the person is declared incapacitated by a doctor, a medical professional. But it could be anything. Your kid moves out of the house, your grandchild gets married, you dye your hair blue. As soon as you dye your hair blue, that power of attorney can kick in, whatever it says in the document, as long as it's not illegal. I haven't seen too many weird springing powers of attorney, but again, it's possible. And so in a document, a power of attorney can be both durable and springing. It just kind of depends on what the trigger is. But in most powers of attorney that we see today are durable, and that includes the statutory form. Just like the advance directive, the state of Georgia, the legislature has created a kind of a standard document. The text is in the statute. It's in the law books. So you can go and download it. It is not quite as complicated as the advance directive, but it is still kind of a mess. I still prefer people get some advice and get walked through the document, specifically because the document allows the person making the document to grant or withhold certain types of authority. And there are kind of all the basic ones. You can access my bank accounts, you can sell my real estate, you can do my taxes, you can run a business on my behalf, those sorts of things. And then there are kind of superpowers, which we don't normally recommend except in very specific cases, where you can give the agent the authority to kind of get out of a joint tenancy, get out of a joint ownership, like a joint tenancy with right of survival. They can get rid of that. They can modify trusts. They can revoke trusts, which is okay in some situations, but in some situations you don't want people to have that authority. So, and if you're doing it yourself and you haven't talked to anybody and you look there and it says, they can do X, Y, or Z, and it turns out Z is probably a really bad idea and makes it very easy to commit fraud or to legally, put your estate in a bad place, maybe you don't want to do Z. So.
Right.
And then the last thing that a power of attorney does, especially the form that we use, is that it nominates a conservator. And just like we talked about earlier, where a guardian is a person who the court appoints to manage your life, your health care, a conservator is a person that the court can appoint to manage your stuff. And just like the advance directive, the power of attorney doesn't necessarily go before a court. You hand it to banks, you give it to closing attorneys, that sort of thing. But an outside party can come in, or anybody can come in and ask the court and say, hey, wait a second, I think this agent is doing a bad job, and I want to have a conservator appointed by the court. And just like with guardian, Georgia law allows the person to nominate conservators who they want. And so the power of attorney form has a space that says, here are the people that I want to be my conservator. And so, it avoids those, or helps avoid or helps shut down quickly those fights over who gets to manage mom's stuff.
Gotcha. Okay. And then let's talk about this last category. I'd never heard of it, the POLST, which is that acronym. First of all, what's the acronym? What is it? What does this do? And when should it be executed?
Sure. So a POLST is a physician's order on life-sustaining treatment. And I just learned about these in January. So, and it's only been around for a few years. And what it is I've actually got a copy. You're supposed to print them on pink paper. So I don't know how the color's coming through, but this is it. It's a two-sided single sheet of paper. It is indeed pink, state of Georgia. Other states, they're different colors and may have a little bit different information. But a POLST is a document signed by a physician. It is a physician's order, so it carries a little bit more weight than an advance directive. It is a little more detailed than an advance directive, and it covers there's some overlap between the two, but a POLST and an advance directive have some areas that, one talks about one area and one talks about the other. So generally a POLST covers kind of three areas, and it's just for life-sustaining treatment. It is just for, hey, are we keeping this person alive? And if so, how and to what extent? So there's CPR, resuscitation, There's breathing intervention. Is someone going to receive oxygen? And then antibiotics, which the advanced directive doesn't cover at all. So those three things are generally what's covered by the POLST. And whereas the advanced directive is binary, it's yes, no. Do you want this? Do you not want this? The POLST has kind of gradations. I don't want anything. I want it all, or I want some things but not others. And so what this document is it's something that you should take in. The person should talk with their primary care physician or some other healthcare provider, who will then sign the document, and then the person will sign the document. And then, again, just like the advanced directive, you kind of hand that out to everybody who is involved with your healthcare.
My question is, why isn't the information within the Pulse just put into the advanced directive and just make it all a physician's order?
Sure. So I don't know why, because the advanced directive is statutory, which means it has to be done in the legislature.
Right.
And you know how easy it is to get things done in the legislature. Whereas this is something that I think was advised by an outside counsel.
Right.
And, who are made up of, the lady who presented it to us was, I believe, a nurse. And she had been fighting for this for a long, long time. So it's a little easier to get those sorts of things done. So it's not a statutory form, but it is, it's great. It's very, very helpful, very, very useful. And we give it to all our clients. When we do estate planning, when we do wills, powers of attorney, advanced directive, we also hand them, each of them, a copy of the POLST and say, I can't do this with you. This is
for your doctor.
There's three choices. Go talk to your doctor.
So, Scott, if someone out there listening in the state of Georgia wants more information about this, maybe needs help with these documents, how do they get a hold of you?
So they can contact me through my website. It's probably the easiest thing to do. It's fields.law, www.fields.law, my last name. You can give me a call. My phone number is on the website, but I'll give it to you, 404-532-9953. You can also just Google the names of any of these documents and Georgia. So Georgia POLST, POLST, Georgia Advanced Directive, Georgia Power of Attorney. Don't get them from other states, and don't get a generic one. So I'm not going to say that the ones that, if you go to Staples, not to single them out, I love Staples. But if you go to Staples and get a medical form or an estate planning form, sometimes those are not specific and they don't comply with Georgia law.
Staples sells those?
I haven't seen them at Staples. I have had people come to me with Office Depot, Office Max. That's what they tell me later. Yeah, I got my mom a will off of Office Max. We bought a form, and those are not great. My firm primarily does probate administration, estate administration, doing the legal stuff after someone passes away. And whenever I hear that someone got one of these forms, either downloaded it or bought it at a store, then my ears kind of prick up, because this usually means that someone's going to end up having to pay us a lot more,
right,
to fix some issues. We're dealing with a couple of cases right now in a will where there's two words that are lacking, and because of that, it ends up costing my client. So far, it's been maybe $700 to $1,000 to fix the problem, just because that's what it costs. Because now we have to go find all sorts of people.
It's $500 a word.
Yeah, exactly.
Take heed to what Scott is saying. It's very important. I would recommend that while you are able to do these things with your loved one, have them sign these documents, have them reviewed by an attorney, particularly Scott, if you can. Lots of great information today, Scott. Super appreciate you coming on, talking about these documents.
Thanks. Glad to help.
Reach out to Scott if you can, and thank you so much, Scott.
Yeah, you're very welcome.
I feel like Scott is like an official co-host of this program for how many times he has been on the show. So we'll have a link to his website as well as his blog post dealing with these issues like the power of attorney, advanced healthcare directives, these type of things for your information and use. Reach out to him if you have questions. Hope you enjoyed the information in this podcast. A lot of great stuff today. If you are, in fact, enjoying the podcast, then please like and subscribe wherever you get your podcast from. Check us out on YouTube. Be sure to hit the notification bell on YouTube. And new episodes every other week. That is twice a month on Mondays. Be sure to check us out then. And with that, folks, we'll see you next time.